bom dia a todos. Agora tem todo esse protocolo, né, de tira a máscara, ajusta o óculos, mas vamos lá. Muito bem. O nosso painel hoje é intitulado Painel América Latina. O painel que pretende debater as convergências e divergências da aplicação do direito da concorrência na América Latina com relação ao controle de concentrações, cartéis e condutas unilaterais, entre outras. Mas não é só. Esse painel tem um significado muito maior, que é uma forma de aproximarmos cada vez mais a comunidade da concorrência latino-americana. Estimados Carolina, María José, Carlos y Miguel, es un placer y una alegría tenerlos en este panel que reúne a representantes de Argentina, Chile, Colombia y México para compartir sus experiencias en materia de competencia. Pero, en su persona, me gustaría saludar a todos los países de América Latina para que cada vez tengamos más participación latinoamericana en esta ponencia internacional de defensa de la competencia del IBRAC. E feito este agradecimento aos nossos colegas, amigos da América Latina, gostaria de brevemente apresentar os nossos palestrantes. Carolina Pardo. Carolina is a partner of Baker McKenzie in Colombia. She leads the corporate compliance team in Bogotá, which devotes its time advising clients in competition, data protection, consumer, and ABC matters. She's part of the global steering committees of Baker McKenzie's Compliance and Investigations Group and of TMT Industry Group. She was part of the global steering committee of antitrust competition of Baker McKenzie and lead the Latin steering committee until July 2020. She is also part of the Latin steering committee of compliance. And the most important part on her CV, she is also a mother of two amazing teenagers. Carlos Mena Labarte. After 10 years in various positions at the Federal Antitrust Commission, COFECE, where apart from being the first head of the investigative authority, he was General Director of Investigations of Cartels and Head of the Planning, Public Relations and International Affairs Unity. He currently advises clients regarding all aspects of economic competition in Mexico. Mr. Mena also has experience in coordinating proceedings in different jurisdictions, especially in Latin America. María José Enríquez. María José is the partner in charge of antitrust and compliance in Morales Bessa, where she specializes in merger review, complex litigation, and behavioral matters. María José joined Morales Bessa in 2016. Before that, she was appointed as head of the anti-cartel unity of the Chilean Competition Agency, the Fiscalía Nacional Económica, where she headed complex and high-profile investigations of collusive conduct in markets such as pharmaceuticals, public procurement, ocean shipping services, construction, supermarkets, and tissue paper products, among others. Miguel Del Pino. Miguel Del Pino joined Marval O'Farrell Meiral in 1998 and was made a partner in 2008. His area of specialization is centered on competition and mergers and acquisitions. His professional work focuses on advising clients and representing them before the antitrust authorities on matters relating to pre-merger control, cartel investigations, anti-competitive investigations, and general market investigations. He has also dealt with mergers, acquisitions, and joint ventures transactions, advising buyers and sellers on the transfers of shares or assets in Argentina. He has been very active in advising foreign clients on setting up business in Argentina and compliance with local regulation. E, finalmente, eu tenho a honra de ter comigo, como moderador deste painel, o conselheiro Sérgio Costa Ravagnani. Sérgio Costa Ravagnani possui graduação em Direito pela Universidade de Brasília, especialização em Direito Público pela Pontifícia Universidade Católica do Rio Grande do Sul e em Gestão e Administração Pública pela Fundação Getúlio Vargas. É procurador da Fazenda Nacional desde 2008, tendo exercido o cargo de procurador-chefe da Divisão de Acompanhamento Especial na Procuradoria Regional da Fazenda Nacional da Primeira Região. Foi subchefe adjunto para assuntos jurídicos da Secretaria-Geral da Presidência da República entre 2016 e 2019. É conselheiro do CAD desde outubro de 2019. Conselheiro Sérgio, como vocês podem perceber, é autoridade neste painel. É ele que caçará a palavra de quem fala muito, é ele que controlará os tempos. Eu apenas obedeço o que a autoridade aqui nos mandar. E dito isto, já passo a palavra ao moderador Sérgio Ravagnani.
Vicente, muito obrigado. Bom dia a todos que acompanham o Seminário Internacional do IBRAC. Quero agradecer o convite que me foi feito para moderar tão distinta mesa, em nome do Lauro, e agradecer, Vicente, por ter a honra de sua companhia e de seu auxílio como moderador neste painel. Este painel é de importância central para o CAD, que possui um leque de acordos e de memorandos de entendimentos com autoridades de defesa da concorrência de países latino-americanos, visando trocas de experiências, melhores práticas, cooperação técnica e na aplicação das leis de defesa da concorrência. Na América Latina, o CAD possui acordos bilaterais de cooperação com as autoridades de defesa da concorrência da Argentina, Chile, Peru, Equador e Colômbia, e faz parte de acordo multilateral com os países do Mercosul para a cooperação entre as autoridades de defesa de concorrência dos Estados partes para o controle de concentrações econômicas de âmbito regional. O Brasil também é signatário da Carta de Paris, assinada na OCDE em novembro de 2018, que consiste em declaração conjunta com melhores práticas sobre leniência, junto com Chile, Argentina, México e Peru, países integrantes da Aliança Estratégica Latino-Americana em matéria de livre concorrência. Essas interações entre autoridades de defesa da concorrência assumem maior relevância quando no enfrentamento de problemas e questões contemporâneas e inéditas, comuns às jurisdições latino-americanas, como os desafios aos mercados desencadeados pela pandemia do Covid-19 e por acentuadas modificações em mercados pelo uso intensivo da tecnologia da informação. É nesse contexto, Vicente, que eu gostaria de endereçar a primeira pergunta comum a todos os nossos painelistas, que é: diante da pandemia da Covid-19, como foi e como está sendo a atuação da sua autoridade de concorrência? Vocês poderiam comentar as prioridades da sua autoridade, como atuou com atos de concentração, tabelamentos de preço, preços abusivos, coordenação entre concorrentes e suspensão de prazos?
Quem tiver o interesse em começar, fique à vontade.
Well, I can start. So, muito obrigada. Bom dia, and I think that's what I have to say in Portuguese, unfortunately, so I do apologize for speaking in English. I have lots of Brazilian friends who speak very well Spanish, so I need to keep up on practicing with them a little bit of my Portuguese. So I'm going to talk about Colombia. In Colombia, the Superintendents of Industry and Commerce, which is the competition authority, did not suspend the terms of a cartel investigation or those related to abusive behaviors, and it did not suspend review proceedings that were ongoing when the government announced the COVID lockdown and the pandemic and the measures against the pandemic in March 2020. The rules to conduct activities related, therefore, to conduct complaints, cartel investigations, leniency through digital means were implemented very well and were published. In June, the SIC authorized new filings for merger review through digital means. In general, the SIC did not flexibilize its policy to combat cartels and announced it would not make any exceptions related to enforcement nor tolerate exchange of commercially sensitive information during lockdowns. No sanctions have been announced, either for merger approvals on the basis of failing firm defenses. These exist, and the statute and would continue to be applied as usual. However, to my knowledge, no failing firm exceptions have been publicized during the pandemic. In addition, the authority, and just very quickly, the authority may authorize a merger if the interested parties can demonstrate that the beneficial effects of the transaction to consumers exceed the possible negative impact on competition that the transaction would have. Parties must demonstrate that such efficiencies cannot be achieved by any other means, must quantify the beneficial effects that will be transferred to consumers, and make express commitments related to transferring those benefits. With respect to the rules for collaboration between competitors, after issuing a resolution outlining standards for collaboration agreements in May, the agency clarified the guidelines and explained the goals that were to prevent the shortage of essential goods to consumers and ensure the survival of companies that may struggle during this period of economic crisis. The SIC ratified the criteria for an agreement between competitors to be considered lawful, but introduced mandatory notification that was not required prior to lockdown. The first of the requirements is generating efficiency gains, such as sharing risks, reducing costs, increasing investments, among others. The remaining criteria include the indispensable character of the agreement, benefiting consumers and not imposing restrictions or limiting competition in the market. Around May, Mr. Barreto, the head of the SIC, sent a letter to retail players asking them to take measures to preserve competition and consumer rights as COVID was spreading in the country. He indicated that the SIC would not tolerate any conduct that harms competition or hinders market development. Shortly after, the authority opened some probes for price gouging, justified on a general prohibition in the law of 1959 to set or maintain inequitable prices rather than on allegations of abuse of dominance. Probe against two companies reflect the position of the SIC. The first one, a British drugstore, was questioned for what the authority qualified as an unjustifiable price increase of antibacterial gels, considered essential products during the health crisis. The second involved a company which increased prices too quickly, to the judgment of the SIC, of breathing masks, goggles, and protection filters without an objective and reasonable justification. So in general, those were the measures. The SIC continues to operate through digital means and has continued to be very active in enforcement actions during these COVID times.
If you want, I can continue with, as I am Argentina
with
the A.
Miguel.
With the A.
Yep.
Ok. Primeiro que tudo, eu quero agradecer a você, a conselheiro Sérgio, Lauro e Bruno pela organização deste painel. É uma grande ideia. E a IBRAC por receber a estes amigos de Latinoamérica. É um orgulho estar aqui. Para mim, também é um orgulho participar do conferência. Esta é minha conferência número 15 que eu participo do IBRAC, assim que é meu 15 aniversário com IBRAC. E I'm going to continue in English. I know that my Portuguese is terrible, but I'm still studying it. And I started to study Portuguese after going to this conference of IBRAC. Let me try to give you in a very few words what is the status in Argentina. On March 20, a complete lockdown started in the entire country, which meant that the entire administration, not only the antitrust tribunal, the antitrust commission, but the entire administration entered into a lockdown that implied a full suspension of the terms. So not only the antitrust matters were suspended, but all administrative proceedings with the general administration were suspended. The lockdown finished in the city of Buenos Aires and the Great Buenos Aires a week ago, but the terms resumed in October 26. So for you to have an example, antitrust in Argentina has not been enforced for a period that ran from March 20 to October 26. During this 8 months, there was, I would say, a erratic action of the Antitrust Commission because they tried to continue with their proceedings, but whenever they sent a request of information or responded a request from the parties, they said, look, I'm asking for this information, but please be advised that the terms are suspended. So they were like doing us a favor. They were acting in favor of us, but with no terms running. So during this 8-month period, I would say that they focused only on merger cases without the terms being continuing. They focused on requesting information, on receiving new cases, and on trying to finalize current cases. I would say that they were erratic, as I said before, because in some times they acted very quick, and in others they acted very, very slow. They focused basically on merger control proceeding and on prices, because the main consequence of the lockdown in March 20 was a decision by the Secretary of Trade of fixing or imposing maximum prices on what they called essential products. All products that were essential for the people in general and were needed for the pandemia, they were subject to maximum prices. And in order to control that the maximum prices regime was complied by the parties, they used basically 3 legislation. They used the supply law, they used the consumers law, and they used the antitrust law. And let me continue with the antitrust part. What they were doing during the month of April, May, and June is basically starting market investigations on those companies that they felt that they were increasing prices because either of an extreme dominant position or a potential collusion activities. So they were controlling the companies through market investigation in relevant sectors in order to see whether they were increasing the prices because of the economic situation in general or because they were committing antitrust behaviors. So the Antitrust Commission focused basically on these 2 matters. Until August, I would say mid-August, the communication with the Antitrust Commission was through emails to the regular emails of the members of the Antitrust Commission. And as from mid-August, they started an electronic filing system, which is called TAD, Trámites a Distancia. And right now, all procedures with the Antitrust Commission with regards to merger investigations are performed through these electronic systems. As the terms resume in October 26, now the Antitrust Commission is focused on conducts, and they are basically sending tons of requests of information and trying to advance with their investigation. So all of us right now are extremely busy because these people stayed for 8 months doing whatever they want without notifying the parties, and immediately after October 26, they sent tons of requests of information and decisions they made during this 8-month period. So with this, I think I'm done with an introduction, and I'm happy to respond any questions regarding this. Thank you.
I will be happy to continue. So unlike Miguel, this is my first time in IBRAC, so I would like to thank you for the invitation. It's an honor and a pleasure for me to join this panel. And I would like to talk to you about the current situation in Chile regarding antitrust competition enforcement. In Chile, actually, I cannot separate the effects of the pandemic from the effects of the social outburst we had a year ago in Chile in October 2019. If you have watched the news, you should know that during October last year, during the whole year, there have been a series of demonstrations and protests throughout the countries, some of them very violent, which have even triggered a process for the enactment of a new constitution in Chile. In this context, antitrust and specifically cartel enforcement has been on the headlines very regularly. Actually, a couple of months ago, the head of the Fiscalía Nacional Económica, the FNE, Mr. Ricardo Riesco, said in an interview that he thought that cartel conduct was one of the causes of the social outburst. And these words are actually backed by data. In a survey done in January this month by the very prestigious Centros de Estudios Públicos, the abuses by companies was one of the 5 main reasons people identified as the cause of the social outburst, with other surveys saying that cartel cases or the lack of jail time for executives involved in cartel cases being another reason for the social outburst. This in a background of very high-profile cases in cartel, dealing with cartel conduct during the last 10 to 12 years. The pharmacy chains, price-fixing cartel, poultry producers cartel, tissue paper products cartel are all very, supermarkets cartel recently, they're all very sensitive products in Chile. So the competition tribunal, which is a specialized tribunal in Chile that deals with the kind of cases, and the Fiscalía Nacional Económica, the FNE, which is the agency in charge of investigating and filing action, actually have had a very remarkable role, first in covering these cases and then bringing action. But the taste in public opinion has been somewhat bittersweet. First, they don't understand, people does not understand why there has been no imprisonment or jail sanctions for executives. We have to remember that criminal sanctions were introduced into Chilean competition law in 2016, right after these cases were made public. And also leniency is actually a hard sell to public opinion. It's often perceived as unfair. So what has been the reaction from the government to social outbursts and this feeling of unfairness and abuse from companies very closely related to cartel cases? They have sent to Congress what is called an anti-abuse agenda. And one of the bill of laws in this agenda is a bill of law to amend our competition statute, Chilean competition statute, which is the GL 211. And we have to remember that in Chile, we have a very strong competition law, very modern. It actually has very hard sanctions for any kind of conduct, including cartels, with actually fines with no ceiling calculated over the benefits from the infraction to a percentage of sales. For example, we have criminal sanctions going from 3 to 10 years of jail time with 1 year of effective imprisonment, actually. You cannot get around that. The FNE, the Fiscalía, has strong powers of investigation of cartels, including down raids, wiretapping, and there's a strong and very successful leniency program. So this is the context in which we have a new bill of law, amending a law that was recently amended in 2016. But what are the objectives of the bill of law? First, it will introduce the figure or the institution of the whistleblower, which is actually not in our Chilean law. Currently, the bill of law says there will be no retribution or payment for these whistleblowers, so let's see how it goes. Also, the bill of law gives additional powers of investigation to the FNE, such as accessing bank accounts and surveillance powers, the power to photograph, to record conversations, and also it increases criminal sanctions for cartel conduct regarding certain products, and I will say it's in Spanish, products that are indispensable para el sostenimiento de la vida de las personas, whatever that means, from 3 to 10 years to 5 to 10 years. And in regards to specifically to COVID, this is my last remark, we actually had different approaches from two authorities, the Competition Tribunal and the Fiscalía Nacional Económica, in regards to the main tension that has been identified during the pandemic. The tension that consists on maybe some degree of collaboration among competitors is going to be needed during this period. Maybe this collaboration has to be done quickly, maybe it's urgent, and maybe there's a public objective behind this collaboration, especially if it refers to the provision of medical products. So what has been the approach of the two agencies? It has been actually very different. On the one side, the Fiscalía, the FNE, issued a statement that says care must be taken to prevent the current state of catastrophe from being abused from unscrupulous as an excuse to cartelize. So instead of facilitating and acknowledging the situation, I would say the Fiscalía is keeping a very strict path. And according to law, there's nothing else it could have done. They don't have the powers to do otherwise. So they issue a warning. And on the other side, we have the Competition Tribunal, which actually issued an internal regulation saying that in case of collaboration among competitors, there will be a special procedure to ask for permission, actually to present a consultation and ask the tribunal to see whether the collaboration between competitors is feasible and under what conditions. And the Competition Tribunal said that they will grant a provisional authorization pending a definitive decision on the case, only limited to maintaining to agreements between competitors necessary to maintain supply and continuity of transportation and delivery service of pharmaceuticals or medical products. So this is a procedure that usually lasts between 8 months to a year, and only after the procedure you can go through with the agreement or contract or transaction. But in this case, the Competition Tribunal says, okay, we're going to have an expedited procedure. Today, though, there have been no cases that have used this special regulation. And finally, in terms of terms, we have not seen any delays from any of the agency. I'm sorry to hear about your situation, Miguel, in Argentina. There has been some delay in the probatory stages because there is an impossibility to take witness depositions. But other than that, it's been business as usual for both the agencies.
Thank you, Maria Jose. If I may continue, Sergio, Vicente, thanks for the invitation, and it's a pleasure to be with my dear colleagues from Brazil and the admired organization of IBRAC, that we are very envious in Mexico that you have this kind of organizations in Brazil. And also I'm very, very honored to be with my dear friends in this panel. It is very interesting to hear the different experiences throughout the region, very different. First, I would recognize that in Mexico, the authorities, COFECE and IFT, especially COFECE, made an enormous effort to remain open for some procedures during the pandemic. So for example, for merger control and advocacy efforts, they were always open. They never closed for these proceedings. But on the other hand, they were closed for many others, like, for example, cartel and abuse of dominance investigations. At the end, they reopened. They made an effort to make a lot of these procedures electronic, except for some formalities, and that's remained. So I think that's a good thing coming out of the pandemic. Unfortunately, as in many other areas of our lives, they haven't been able to get back to normal. So for example, there haven't been any searches this year. We do not see them in the near future, really. The same with in-person interrogations. So many operative challenges remain, I think, and they don't have an answer for that. Regarding their specific response to new challenges arising from the pandemic and the economic downturn in the markets, I think COFECE came up with new procedures to quickly authorize, for example, collaborations among competitors for some markets that were directly related to the pandemic. Unfortunately, this new tool was not clear, the procedure was not clear, and they required to prove that these collaborations were not anti-competitive, which was, of course, very difficult. So actually, we don't have a good procedure on that. I actually believe we should have a tool as the one you have in Brazil for authorizing this kind of collaborations quickly. I think that's very interesting what you have there. On other matters, COFECE has been very aggressive with practices that could be considered cartel conduct, has made public warnings to some industries for possible illegal exchanges of information. So, for example, the alcohol industry, the Association of Real Estate Developers and Tenants. In fact, COFECE just started an investigation in the real estate market for possible cartel conduct in how malls or other tenants have discussed prices, discounts, negotiation terms during this pandemic. I think we're still to see how they react to other challenges, such as the incredible restriction of output and price increases that we are seeing in some markets. Unfortunately or fortunately, you never know. We don't have the authority in Mexico for COFECE to regulate prices or try to control prices, as Miguel described is the case in Argentina. And I think an interesting topic is also the challenges of the failing firm defense, the failing firms that they are, of course, many failing firms in many markets as a result of this pandemic. And we still don't know how COFECE will treat that defense in merger proceedings. So a mixed experience in Mexico.
Vicente, posso fazer o uso da palavra antes de passarmos para a próxima questão?
Deve, como eu disse, o senhor manda aqui, a gente só obedece.
Obrigado, Vicente. Apenas esclarecendo a audiência, foi feita uma pergunta agora em comum para todos os nossos painelistas, que eu gostaria de brevemente comentar em nome da autoridade brasileira, e depois passaremos a algumas perguntas individuais a cada um, que nós dividiremos, Vicente e eu. Com muita satisfação escutar o relato de advogados a respeito da conduta das autoridades dos países latino-americanos aqui representados e dizer que, pelo lado do CAD, pelo lado de autoridade, nós tivemos um grande esforço em não paralisar principalmente as análises de ato de concentração. O CAD no Brasil, ele foi pioneiro em utilizar a informatização, em ser um órgão que não faz uso de papel, e isso nos auxiliou no trabalho remoto, de tal forma que apenas os prazos processuais que corriam em desfavor dos particulares em investigações e em condutas foram suspensos entre os meses de março e de agosto, mas isso foi uma lei federal que atingiu a todos. Enquanto agências reguladoras no Brasil, por exemplo, suspenderam prazos processuais de procedimentos que beneficiavam aos administrados, faço aqui um paralelo aos atos de concentração, no CAD, ainda que tenhamos tido uma certa dificuldade em obter respostas a testes de mercados, as empresas que estavam em dificuldades para funcionamento naquela época, nós não tivemos nenhuma paralisação em relação a essas atividades, que seguiram com os nossos técnicos de casa e, inclusive, observamos uma diminuição no prazo de análise de atos de concentração, ou seja, isso serviu como uma experiência piloto, a partir da qual nós devemos implementar o teletrabalho mais fortemente em nossa rotina. O CAD fez uma emenda ao seu regimento interno para permitir o prosseguimento das audiências com advogados e também das sessões de julgamento de maneira virtual, de forma que o calendário de sessões de julgamento foi totalmente cumprido, e também aqui agradeço ao Carlos pela lembrança, o CAD editou uma nota informativa sobre colaboração entre concorrentes, e nesse aspecto eu congratulo tanto as empresas quanto a Superintendência Geral do CAD, que fizeram enormes esforços em conversas rápidas para dar orientações rápidas na forma de um fast track, e em apenas uma oportunidade o tribunal foi instado a se manifestar. Todo o restante foi esclarecido na Superintendência Geral. E, por fim, houve também um incremento da atividade do nosso Departamento de Estudos Econômicos, porque no Parlamento Brasileiro houve uma série de discussões sobre tabelamento de preços em produtos essenciais, como medicamentos, como mensalidades escolares, gás de cozinha, e o nosso Departamento de Estudos Econômicos providenciou um excelente trabalho de advocacy esclarecendo os possíveis riscos à concorrência, de suprimento, fornecimento e aumento de preços nesses projetos de lei. Feitas essas considerações, Vicente, passando agora continuando as nossas perguntas, dando início à rodada de perguntas individuais, eu lhe passo a palavra para a pergunta à nossa painelista Carolina Pardo.
Obrigado, conselheiro Sérgio. E antes de fazer o questionamento, a pergunta à Carolina, eu gostaria de parabenizá-lo, em sua pessoa, todo o CAD, o trabalho que o tribunal, que a Superintendência e o Departamento de Estudo Econômico fizeram durante a pandemia, o que deu muita segurança aos jurisdicionados. E é interessante esse primeiro rodada que nós tivemos para observar as diferenças entre os países da América Latina e que esse painel também possa contribuir para um best practice, para as melhores práticas que sejam trocadas entre os países, entre as autoridades. Então, por favor, transmita meus parabéns ao Dr. Alexandre Barreto, Dr. Alexandre Cordeiro e ao Dr. Guilherme. Muito bem. E vamos, então, uma rodada de perguntas aos nossos panelistas. Mas também, quem tiver pergunta para fazer aí da audiência, na parte de baixo da sua tela tem o perguntas e respostas, o Q&A. Fique à vontade, faça a sua pergunta, pode fazer em português, que depois ou eu ou para o conselheiro Sérgio direcionaremos os questionamentos aos nossos panelistas. Mas eu começo perguntando à doutora Carolina. The Colombia Authority concentrates powers related to data protection, consumer protection, and antitrust competition. In recent times, there has been a discussion around having authorities that have all these powers to try to face adequately the new trends in a coordinated way. What are positive aspects from this situation, and which challenges does this trigger?
Thank you, Vicente. Well, I think that we have all witnessed discussions on the benefits or the challenges on the intersection between consumer protection, protection of personal data, and competition. We also have seen some commentators and even agencies arguing that centralizing in one agency the powers to investigate and enforce all three types of themes or topics is a good goal, given the new trends and the new dynamics of markets. Others even argue that regulators need to rethink their approach by considering the issue of privacy as part of the question of quality, which is a crucial factor for antitrust enforcement. I will not argue against that. However, in as much as I believe that although these matters may be adjacent and very close, they are different and have different goals. And so must the application of the respective laws and procedures. In Colombia, one single agency, the SIC, combines the investigation and enforcement powers for data protection, consumer protection, data protection, amongst others. Others include IP, patents, technical standards. So you can appreciate that the SIC is a very powerful body in Colombia. It has a lot of employees and it has a lot of responsibilities. However, so far, the authority has kept separate the investigations and enforcement powers for these different matters. This is based also on the law, since the procedures, the laws that the agency has to apply in each case and the enforcement actions, even the fines, are different for different aspects. Even if all of these ultimately report to one single individual, who currently is Mr. Andrés Barreto. A bit of explanation about the structure of the SIC. The head of the SIC is appointed by the president. However, in an intent to keep the independence of the regulator, the law established that the term of the superintendent and other superintendents, not just the industry and commerce, must be the same as the term of the president. In Colombia, the superintendents have important powers to oversee critical functions within the government. And these procedures or these provisions allegedly intend to shield the independence from political influence and other type of pressures to these officers. Within the SIC, there is a consumer protection deputy, a data protection deputy, and a competition deputy. And each one of them has specific functions, and although they have similar procedures, sometimes they have to operate in ways that are not identical. For instance, the data privacy division, if the data privacy division decides to open an investigation regarding data privacy matters, after the investigation, it is the director of investigations who decides to impose a sanction or not. And the matter will go to the deputy superintendent for a reposition or an appeal. In the case of antitrust matters, it is the antitrust division which decides if it opens an investigation, and then the deputy superintendent for the protection of competition recommends to sanction or to file the case. And then it is up to Mr. Barreto, as the head of the competition agency in this case, who decides if the fine will be imposed. The levels of fines, as I mentioned, for data protection and consumer protection are around $450,000 on the caps, while the fines for competition violations are around $25 million, the caps. In any event, during this administration, the SIC and Mr. Barreto himself have been very vocal about the prominence of data protection enforcement, and a number of cases from the data protection division have been actually ruled and taken. The benefits of all these powers concentrated in one single agency should be summarized by a consistent approach by the regulator in charge of them. This is true with respect to major cases. Some may argue that the area of specialization requires the teams specifically devoted for each matter. I think that the SIC fulfills this requirement. Some voices, however, have suggested that an agency that concentrates so many powers and so many topical powers in this era, like privacy, competition, and consumer, would require a body of colegiado, I don't know how to say this, such as we see in COFECE, and also separating powers, as we see in Chile, as we were hearing a minute ago. However, in Colombia, the institution is the one that is in charge of investigating and enforcement, and it is only headed by one single individual. So I don't know if with that I answered your questions, Vicente.
Vicente, gostaria de comentar a resposta ou posso passar para a seguinte?
Pode passar, que eu acho que nós temos várias questões interessantes, então é melhor fazermos as questões e depois, com o tempo, a gente abre para um debate final.
Claro, aqui no Brasil, neste ano, a nossa Lei Geral de Proteção de Dados Pessoais entrou em vigor neste ano e os primeiros conselheiros já foram aprovados pelo Senado Federal, e a nossa lei é inspirada no modelo da lei europeia, e com certeza temos muito a aprender com a experiência da Colômbia nos anos que se seguirão para a estruturação da nossa Agência Nacional de Proteção de Dados, que temporariamente ficará na Presidência da República por 2 anos, mas que depois a ideia seja também uma agência autônoma. E, ao que tudo indica, no Brasil, continuaremos tendo agências distintas para defesa da concorrência, defesa do consumidor e proteção de dados pessoais. Feito esse esclarecimento, que, desculpem até em benefício do tempo, mas eu não consegui segurar, a próxima pergunta é para o nosso panelista Carlos Mena. We understand COFECE has been very active in advocacy efforts with opinions and market studies. Is this because the new central government is less market-friendly? Are these efforts effective?
Obrigado. That's a great question. There is an important change in government policies and economic regulation in Mexico since the new president took power 2 years ago. many economic sectors that were opening to competition, that were opening to foreign investment, such as, for example, the energy sector, have been now the object of new protectionist measures, new regulation. And yes, I believe the government is less market friendly. Some say we have the new Lula. I really hope it's Lula, not Chavez, but we're still...
Or Cristina.
Or Christian, still to see that. It's true, this has led COFECE to critique a lot of these measures and even to challenge these measures before the courts. Something that is very good, we think. It is only possible thanks to the constitutional independence that COFECE has. For example, they recently challenged before the Supreme Court an order from the central government that restricts competition from new clean energy production companies. And that's been very powerful, very important for the Mexican market. We're still to see the resolution from the court to that. It is also true, as you mentioned, Sergio, that they are using more the public opinions and the advocacy to Congress and central government to try to influence public policies. But also they have had an agenda of market studies for quite some time. They have good market studies in the financial sector, the medicine markets, and some days ago, for example, they made public a very interesting study on supermarkets, where they say that Walmart has an important market power that pressures both the brick and mortar and the online channels. So that restricts competition, at least from what I understand from that market study, that restricts competition from Mercado Libre or Amazon to participate in general in these markets. No? I think regarding effectiveness, there is a mix of experiences, I would say. Some efforts have been very effective in some markets where regulators are open to critique and opinions from COFECE, but many other market studies end up in the trash, really. So my view is that there needs to be a more comprehensive strategy of advocacy, trying to engage with sectors, to engage with decision makers. I think only creating an opinion or a market study is not sufficient, although it's very, very important. So the communication strategy and using other stakeholders is very interesting when they do that.
Muito obrigado, Carlos. O seu comentário inicial me fez também imaginar o que será da concorrência nos Estados Unidos, ou com o Biden ou com o Trump, né? Vamos aguardar para descobrir. Mas muito bem, já vamos mudando, agora vamos para o Chile. E eu tenho uma pergunta para a Maria José. We understand that there have been recent developments regarding leniency in Chile, as tensions between the Competition Tribunal and the Supreme Court. Could you please explain the context of such tensions?
Sure. Thank you very much, Vicente. First of all, I wanted to comment on what Carlos just said. And then answer your question. It's how important it is to have independent agencies. It's paramount to the effectiveness of the system. And also in Chile, we also have the power to conduct market studies by the agency, but they can end in investigations or recommendations for changes in the law. So that's what gives the effectiveness, and maybe that could be something that could be explored in the law. So they don't get to be an opinion and then put inside a drawer. And as to your question, Vincent, that was a good story. Now, this is a sad story in Chile for leniency. And this is in the context of the tissue paper products cartel, where we had two players, and both of them filed for leniency. And this is a story also of a badly institutional design in regards of leniency. So what happens according to law is leniency applicants file before the Fiscalia, but Fiscalia is not the agency that sanctions anti-competitive conduct. So Fiscalia has to file an action before Competition Tribunal, and that is the tribunal which decides, makes the final decision as to the exemption of fines or the reduction of fines regarding leniency applicants. So what happened in this case is that this is a cartel of two players where both of them filed for leniency. So one was, there was a first in and second in. So the first in should receive complete exemptions from fines. But the second one in said he should not receive full exemption because he was the organizer of the cartel, and actually this company coerced me into entering into the collusive agreements. And according to law, this is the one exception. You cannot grant leniency to the organizer of the cartel that exercises coercion to the other companies to enter into the cartel. So what happens is the Competition Tribunal actually agrees with the Fiscalia and says, I don't see that there is actually coercion because all the evidence presented refers to economic coercion, meaning if you don't enter into this agreement, I'm going to compete aggressively. So the Competition Tribunal says, no, the threat of competing aggressively should not be considered as coercion. Actually, Competition Tribunal, and this may have been a mistake, the Competition Tribunal says, I will interpret, I will start that coercion is the threat of physical force, a physical threat, or a irresistible psychological threat. So the case goes up to the Supreme Court. Again, we have the second in arguing that the first in shouldn't have received full exemption because he wanted to be the first in and be exempted from fines. And the Supreme Court overturns and says economic pressure is and has to be considered as coercion because it undermines the necessary adherence to a collusive agreement, meaning there is no will. The will is somehow not perfect, the will to participate in a collusive scheme. So economic pressure, threat of competing very vigorously should not, is actually a kind of coercion. So the Supreme Court revokes the leniency benefits from the first in, but actually instead of giving the exemption to the second one in, it says, you know, this conduct, this price fixing that lasted above 10 years is so serious that I would not give you leniency to the second in. So actually it sanctions both companies for $15 million. And why do I say this is a sad story? This is a story, we all know that predictability in terms of leniency is paramount. You have to create incentives to company to go through and present a leniency application. This is a very hard process. The ones that we have worked on this know that. We have executives coming in for a long time. It's awful for the companies, for everyone. So if you're going to go through that process, you need predictability. Well, on the good side, now we know what coercion is. Because now the Supreme Court has defined this institution. On the bad side, we still have a problem of institutional design. It should be the decision of the Fiscalia, the one that receives leniency applicants, that counts. This thing happened because we have a different entity, the Supreme Court, deciding on the leniency that was presented or filed before the Fiscalia. So we'll see how it goes from now.
Obrigado, Maria José. Agora, eu gostaria de fazer a última pergunta dessa primeira rodada. E agora vamos para a Argentina. Miguel, what is the status of the creation of the new antitrust tribunal for the antitrust law that was passed in 2018? When is the merger control system moved to a pre-filling system?
Thank you, Sergio, for that question, which is a very relevant question because of the second part of your question. The antitrust law was amended in 2018, and it basically introduced three important questions, among others. But for me, the three key issues that were introduced by this law were basically try to create a new enforcer agency, which is a new independent enforcing agency. And once this enforcing agency is set up, shifting the system of merger control from post-closing analysis to a pre-closing analysis. And the third one, it is the introduction of leniency in Argentina. We did have cartel prosecution over the last 20 years, but we didn't have leniency. And leniency was brought by the law and is currently enacted and it is in place. As you mentioned, the law was passed in May 2018, and the law provided for a special procedure, which is a contest formed by an independent jury that will elect the members of the new antitrust authority, and immediately after they are elected, the members require consent by the Argentine Senate, which is one part of the Federal Congress. President Macri initiated a procedure at the beginning of 2019 in order to appoint the members, but was never able to finalize that contest. He left the government on December 10 last year. The new president, Mr. Fernandez, appointed new members of the Antitrust Commission, which is the previous authority. And unfortunately, they decided to cancel the previous contest and decided to call a new contest. I had personal conversations with the president of the Antitrust Commission, the current president of the Antitrust Commission, Mr. Rodrigo Luchinsky, who was appointed by President Fernandez, and he's very much interested in continuing with appointing the new authority. And he assured me that one of his priorities and one of the priorities of this government is continuing with the creation of this new authority. Unfortunately, the pandemic suspended everything all over the world, not only in Argentina. So we still have to see whether they will continue with this idea of initiating the procedure for appointing the new authority. I fully agree with Maria Jose in there that for the antitrust regulations to be effective, an independent authority needs to be in place. And that is, in my view, one of the problems that Argentina has had over the last 40 years, in which we had antitrust regulations that were enforced by a complete dependent authority.
Obrigado, Miguel. Desejo sorte à Argentina na mudança do sistema de notificação prévia para o sistema de notificação prévia. Aqui no Brasil, essa alteração consumiu dedicação do CAD no início da década de 2010, quando, em 2011, a nossa lei instituiu a pré-notificação. Àquela altura, o CAD já era uma autarquia independente, com conselheiros com mandato, mas certamente com a criação da Superintendência Geral e essa mudança na lei, houve grandes avanços no CAD e devidos também a um grande esforço do pessoal para implementar essas alterações. A minha próxima pergunta, agora já para a segunda rodada, revisitando os países, é para a Carolina. Vamos para a Colômbia. We have heard that the Colombian Competition Authority, SIC, is very active in terms of down rates. How has this worked during these COVID times, and what aspects would you highlight on these new trends?
Yes, indeed. The Colombian Competition Authority, the SIC, has been very, very active from not just during the pandemic, but from long ago in developing down rates. The powers come from the Colombian Constitution and the regulatory decree that empowers the SIC to perform down rates when it suspects that a party is performing illegal conduct and there is a perception of risk that the necessary evidence to undertake the investigation may be lost. So the SIC may undertake visits of inspection, surprise visits or done rates, during which it can ask for books and records from the company and the individuals. It can also ask for depositions from the individuals within the company. But perhaps one, and I think that's something that is common across all jurisdictions or jurisdictions that have those functions. But one thing that has created a lot of concern and sort of surprise is that in Colombia, the authority does not need a judicial warrant to undertake done rates. And this was subject to a lot of debate. And in 2019, the Constitutional Court confirmed that the judicial warrant was not required because these powers come from the law. I have to say that these powers are not only for the superintendents of industry and commerce. There are other administrative authorities, like the tax authorities, that can undertake this type of done rates without a judicial warrant. So what requirements did the Constitutional Court impose? The administrative authorities must disclose the purpose of the investigation and cannot intercept communications. They should not include information stored in personal accounts or officers, and I will refer to this of officers, and I will refer to this in a minute, because with the pandemic and the working from home environment, that has proven to be a big challenge. And they should limit the collection of data to the purposes that they announce at the beginning of the visit. The authority has powers to impose fines as high as $25 million for failure to cooperate or to obstruct the authority's visit. Of course, not that the authority has not imposed fines that high, but the possibility is that the companies and the individuals can be subject to fine. As you all have probably experienced, a pandemic has triggered challenges and compliance for parties, but also for the authorities, because these type of visits are no longer a possibility to the premises of the companies. Information is gathered, and many parties will probably continue to work remotely after the pandemic. But during these lockdowns, sadly, they seem to be extending forever, hopefully not, the efficiencies of done rates have been reduced, and therefore this entails a reinvention of the done rates approach. The SIC has started to make virtual interviews to parties when gathering information during the pandemic. And the way it operates is it sends a link, and parties have to connect to a link such as a Zoom link or other type of technology. And then in some instances, to the surprise of many, the authority has even requested remote access to the files of the computers of the people that are being interviewed. This, of course, is a huge challenge. There is not a clear position of what this can trigger. But what I can see is that this will continue to be in the discussion, because I think that we will need rules on how these interoperability initiatives should be regulated. There has to be some positions from statute or from authorities that are clear and provide transparency on how integrity of data will be kept, and how cybersecurity and loopholes on security will not be triggered by these type of investigations. We at Baker McKenzie, we have performed a huge study on compliance, and we see that there will be a huge expenditure on technology from companies around the world in an attempt to, of course, continue to facilitate communications from their officers working from home or working remotely. And technology has a twofold. It can allow a more efficient control and compliance matters if it's properly designed to do so. And it can allow the authority to more effectively undertake its functions. But what I say is that I believe that it is absolutely necessary that the authorities and the government start thinking of frameworks that provide certainty, that provide transparency, that are keeping due process in these instances, as it is important that these functions are kept, but also that due process and now cybersecurity and security of the data are not put at risk. So I would suggest that companies involve the compliance function in their procurement decisions on technology, as this will probably be a key aspect going forward after this pandemic. Thank you.
E a Carolina falando, eu não tive como não lembrar, Carolina, do evento da ICN o ano passado em Cartagena das Índias. Muito bem, agora vamos para o México com o Carlos Mena. Carlos, a COFES tem feito um trabalho bastante interessante, inclusive em economia digital, com estudos. Aliás, falando em COFES, transmita meu abraço ao Sérgio, da COFES. Mas eu tenho uma pergunta aqui que relaciona a concorrência com o órgão regulador de telecomunicações. We have heard there have been tensions between COFES and IFT, the telecoms regulator that is the competition authority in the telecoms and broadcasting markets. Why do you think the tensions are incrementing now?
Yes, there has been many problems recently between IFT and COFECE, and as you say, Vicente, unfortunately in our system, COFECE is the antitrust authority for all markets except telecoms and broadcasting, where the Institute for Telecommunications, the IFT, has sole jurisdiction. I do think it is a bad institutional design, but that is what we have. I think the tensions are incrementing because of all these gray areas where telecoms and other markets have no clear boundary. The increased importance of the digital markets has created more tensions and more interest, I believe, for both authorities to remain relevant. The most recent case involves Uber trying to buy Corner Shop. Mexico is the only jurisdiction where this deal has not been approved. Chile approved this very quickly with a very good analysis, and we're still waiting after more than a year for a decision because the regulators engaged in this jurisdictional fight that took 6 months to resolve in the judiciary. Also, COFES is taking its time now, but that is a different story, and we're still waiting for this kind of cases that involve digital markets to be resolved. Now we see that this issue will continue with investigation also. COFECE just announced a new investigation to prove the digital ads market. And some days later, IFT announced an investigation to prove the search market, the social networks market, and the cloud computing market. And we know that both authorities think they have some form of jurisdiction over these markets. So we'll see if new fights between authorities happen because of these new investigations. Some challenges remain in terms of also how they interact with their counterparts around the world. Some say they are copying this kind of investigations from other authorities. One of them being CADE, that they are copying some of these investigations from CADE. And it is very difficult to do this kind of investigation in digital markets. And if apart from that you have a jurisdictional fight, it creates a lot of uncertainty for companies. So I agree that it is a good idea to review compliance practices in general, as Carolina mentioned, and especially in the digital markets arena.
Obrigado, Carlos. Relacionamento entre autoridade antitruste e agências reguladoras geralmente tem essas questões fronteiriças. No Brasil, o CADE mantém acordos de cooperação com diversas agências reguladoras. Agora, passando para o Chile, gostaria de fazer uma pergunta para Maria José. We have heard that there has been a merger case in which the agency accepted a failing firm defense in Chile. Could you please refer to this case and whether you think this could be the first of many to come?
Thank you very much, Sergio. I think the issue of distress M&A, it's a very interesting topic in the context of coronavirus. And I would say also that the key word today, at least in Chile, and I would love to hear what's happening in other jurisdiction is expectations. So we are expecting to see a wave of mergers and transactions that associated with bad economic results due to the economic crisis from coronavirus. We have not seen that yet. So we are expecting that. We're also expecting the authority, the Fiscalía, to lower the thresholds that trigger mandatory pre-merger review. The head of the Fiscalía has announced it during the year. He says to reflect the lower sales that companies are getting this year because of coronavirus. Again, expectation. We are less than 2 months away from next year, and we have not seen that yet. What we have seen is only one case decided by the Fiscalía, which is in charge of pre-merger control review, in which one company used the failing firm defense to get the transaction cleared. Is in a transaction in the gas station markets with our you may know it's local markets, geographically speaking. So in these geographic markets, we have a big player that has been buying a lot of gas stations, independent gas stations, until the Fiscalía, the FNE said, okay, next time you have to come forward and go through the pre-merger review. So this is one of that cases. And the case refers to the concentration of this local gas station market. So in theory, it should have been a case that should have been blocked, or at least approved with very strong conditions, basically blocked. But the FNE approved the case and accepted the failing firm defense. This is not in the law, but it's in the Fiscalía, the FNE's guidelines. However, the requirements are very, very high. They refer to basically, you have to prove that the company in crisis will exit the market in the near future, and you have to actually prove this. Such exit will result in inevitable disappearance of the assets of the company from the market, and also, and this is the hardest part of this kind of three-pronged test, is you have to prove that there is no other less harmful option in competition terms to preserve the assets of the company that's in crisis in the market. So that would be the hardest part, because you will have to answer why isn't there a more suitable buyer of these assets. But still, the question is, okay, are we going to see more of this? Is this a trend? In my view, not yet. We haven't seen any other case of failing firm defense. In very strictly speaking, this is not related. This case was not related to coronavirus, so it's nothing in regards to the pandemic. And we're still expecting, we're still waiting for this big wave of distressed M&A. We have not seen this yet, at least not that has gone through the pre-merger review process or regime in Chile.
Eu queria agradecer, Maria José, a sua participação também. Interessante a questão da failing firm, que sempre volta em períodos de crise. Isso aconteceu em 2008 e 2009, foi um dos temas na conferência anual da ICN, e agora com a pandemia, infelizmente com a pandemia, volta a questão da failing firm defense. Mas, movendo para a Argentina, vamos ao Miguel Del Pino, que, como ele disse, ele faz o seu debut em eventos do IBRAC, que é a 15ª participação. E igual ao Miguel, nós temos outros amigos da Argentina que são assíduos frequentadores do IBRAC. Então, um abraço ao Gabriel, ao Julián. Não sei quem tem mais participação, mas todos uma participação muito significativa. Muito bem. Miguel, an issue that we see in Argentina is the lack of enforcement of the antitrust law compared with other countries. In your opinion, which are the ways to reinvigorate antitrust in Argentina? Which sectors of the economy are currently out of the scope of the Antitrust Commission?
Thank you, Vicente. You are right about that. I'm not the only one Argentinian participating. Julian, Gabriel have participated many, many years in this conference. So it is a group of Argentinians going to the conference. You perform a very good question, and that is completely related to my first response. I really believe that by creating an independent authority, the government will reinvigorate the powers of an antitrust authority to start investigating. If I have to analyze what the Antitrust Commission, the current Antitrust Commission, has done this year was basically follow the interest of the Ministry of Economy. And those were basically try to lower inflation by not allowing increases of prices. And the only useful use that they found for the Antitrust Commission is controlling price increases. And that's why they started investigations during April and May on certain sectors related to essential products to attack the pandemic. So the main issue is creating an independent authority. And besides that, I would add that the constant changes that Argentina has had with the authority because of the changes in the government also attacks I would say the substance of the Antitrust Commission. During the last 4 years, during the President Macri government, we had a very good Antitrust Commission with a group of people that was prepared with a very heavy antitrust background, and they did a lot of work not only on merger conducts, but also on mergers, but also on conducts, market investigations, and even contacts with the rest of the colleagues in the region and in the world. Now we have a new antitrust commission with new authorities that were appointed by President Fernandez. So it's like starting again. We still have to see how Mr. Luczynski will react and how the rest of his colleagues will react. For the moment, what we are seeing is basically work jointly with the Ministry of Economy in trying to hold the problems that the pandemic is creating to the Argentine economy.
Muito obrigado, Miguel. Então eu devolvo a palavra ao conselheiro Sérgio.
Obrigado, Vicente. Temos ainda 15 minutos restantes. Talvez seja tempo para comentários as duas interessantíssimas perguntas que nós recebemos da plateia. Eu começo pela primeira recebida em ordem temporal, que é do Lauro. Lauro say, besides the mentioned collaboration with CADE, do the antitrust authorities in your countries work in collaboration with other jurisdictions? Do the authorities normally request waivers authorizing the collaboration and exchange of information with other jurisdictions? Fica aberta a pergunta para os nossos panelistas, quem quiser comentá-la. Carlos.
Yeah, I can start. I think this is a very, very interesting and very important question. I think the issue with waivers is something that's come up many times in Mexico. More recently, specifically with the cooperation between agencies in Latin America or other countries, rather than just the kind of collaborations that we were used to with Europe or the US, no? And I think we've experienced a good use of the two models of waiver letters. One is the procedural waiver that lets authorities coordinate for how to advance an investigation, the procedural issues in the investigation. And the other one is the more substantive waiver to exchange information relating to what they have been receiving, specifically or more importantly through the leniency program. And I think it has been a good use of the ICN model. As Vicente comments, ICN is a very important part of the international cooperation between agencies. And I think this is one area where the models that were proposed by the ICN have been very important for the use of waivers. We actually know of a recent case where COFECE is cooperating with CAGE to discuss how to proceed in a specific investigation, thanks to this kind of waivers that were produced by the parties in both countries. So it's very important.
For Argentina, sorry, conselheiro.
Imagina, Miguel, eu só ia perguntar mesmo se mais alguém gostaria de responder a essa pergunta, senão eu passaria para a próxima, mas por favor, fica à vontade.
No, thank you. I was going to say that in Argentina, the exchange of information between the different authorities is something that is taking place mostly in merger control filings. I personally participated in 2 cases in which the Antitrust Commission requested information, one to the US, the other one to CADE. And in both cases, there were waivers present, both from the Argentine side and the Brazilian and the American side. And I would say that Argentina is basically following what the US performed. So in the first case of exchanging information, I'm pretty sure that the FTC suggested the Antitrust Commission to request waivers, and that's why basically they called me and said, look, I need this waiver because I'm speaking with the FTC about your case.
Yeah, I think it's the same for Colombia. The SIC has been very active, and as Carlos was mentioning, it's very focused on ICN models and suggestions. We saw a difficult bump with respect to exchange of information between agencies about 2 years ago with the tissue cartel case that covered many countries in South America. And this was a leniency application that was filed in Ecuador, and Ecuador then disclosed the confidential, or what the parties thought was the confidential information, with the Andean community in an attempt to continue the proceeding. So I think that after that, authorities are looking to the ICN suggestions. This was very discussed, and there was a lot of challenges about this. And also with respect to merger control, I have also received and taken part of cases in which the SIC has asked for waivers to convey information to the FNE or to the Peruvian authorities. So that is happening, definitely.
And just to answer this question, is the same until it's very common in the context of cartel investigations and merger review. It's very, very commonly used.
Obrigado. Nós temos uma última pergunta da plateia que veio via chat. Felizmente, nós ainda temos 9 minutos. Quem pergunta é Sebastián Ferreira Romea, da Argentina. His question relates to the intersection between public procurement and competition law in the context of COVID-19. He asks, has there been any Latin America regulation issued or antitrust investigations triggered setting stricter procurement controls on the conduct of national governments?
I can start if you want. As it was a question posed by an Argentinian. No, nothing took place during the pandemia, but this is a good question because this is something that the Antitrust Commission was focused in Argentina during 2016. I believe it was 2016. There was a special fund provided, I believe, by the BID, the International Development Bank, the IDB, to focus and study how procurement was taking place in Argentina. And it was a study performed by the Antitrust Commission and the Anti-Corruption Agency, jointly with the IDB. They performed the study, and then they trained the different procurement offices of the different ministries so that to avoid one, anti-corruption, and then cartel cases or agreements agreements in order to present biddings in public biddings. So this is an issue that was investigated by the Antitrust Commission and is something that really concerns the government.
What we've seen in Mexico is that the public authorities are trying, in fact, to circumvent the open process public procurement rules, and they use as a pretext the pandemic to do that. And what we've seen from COFECE as a reaction to that is that they are making more efforts and more advocacy efforts to try to protect the open bidding process that is mandated by the law, and recommending that authorities don't use these exemptions and don't use this pretext of COVID to circumvent that process, because that in fact will affect competition in the market. So I think it's a real danger that governments do that. No?
Yes, I agree with Carlos. And in Colombia, there were some decrees at the beginning of the pandemic that were flexibilizing registrations, that flexibilized some rules for public procurement. And the Constitutional Court struck some of those provisions because it considered that they were not justified to do so. Currently, there is also a bill of law that intends to modify some of the provisions regarding competition in Colombia. And one of the points that the senator has highlighted, we don't know if how far this will pass, but it says so far that no public entity will be able to demand exclusivity for the import of a product if the party that requests the purchase or the procurement of the products to the manufacturer or the distributors authorized in the world are contacted. This is somehow confusing. And I think that the governments will need to think, or at least the Colombian government will need to think a little bit more about this. I don't know what will happen in Congress. So keep posted about that.
No, just to end the conversation, I recommend you to check the newly published study on public procurement from the FNE. It's a very complete study, and even though it's based on the study of local public procurement, I'm sure very much of the problems are the same in other Latin American countries. And in terms of prices, there has been no cases in the competition tribunal for price gouging or excessive pricing in the context of the pandemic. There was a bill of law trying to set or fix prices for certain products. I don't think it's going to move forward. It's not going to move forward. Already the FNE has said it's certainly a bad idea.
Conselheiro, nós temos uma última pergunta aqui da plateia, porque não temos mais tempo. Então eu farei a pergunta aos nossos palestrantes, só que a resposta tem que ser objetiva, sim ou não, porque nós não temos mais tempo. E ao término, eu pediria que o conselheiro Sérgio fizesse o encerramento deste painel. Então, da minha parte, eu queria agradecer desde já a todos vocês, Carlos, Carolina, Maria José, Miguel e a todos que nos acompanharam por esse dinâmico e interessante painel, que ele sirva como uma best practice para os países da América Latina. E a pergunta que vem da plateia é do Paulo Casagrande, nosso colega, amigo aqui do IBRAC. A pergunta dele é: do you see the different degrees of impacts of the COVID pandemic in the economies of Latin America countries as a factor that can lead to more divergence in the respective antitrust regimes in the region? Fiquem à vontade.
Answer is no. Short.
I don't either.
Yeah, me too. I don't see it.
I say yes, just to disagree with my colleagues.
Very well. Conselheiro.
Obrigado, Vicente. Mais uma vez, quero agradecer a presença do Miguel, da Maria, do Carlos, da Carolina. Foi um prazer e foi uma experiência muito enriquecedora participar dessa mesa junto com advogados tão atuantes e tão destacados nessas diferentes jurisdições. Para mim foi uma honra ter recebido o convite do IBRAC para moderar essa mesa e renovo os meus agradecimentos ao IBRAC, na pessoa do Vicente. Muito obrigado.
Obrigado.